NACDL is the association of the nation's criminal defense bar.
This project is supported by grant number 2019 YABXK001, awarded by the Bureau of Justice Assistance. The Bureau of Justice Assistance is a component of the Department of Justice's Office of Justice Programs, which also includes the Bureau of Justice Statistics, the National Institute of Justice, the Office of Juvenile Justice and Delinquency Prevention, the Office for Victims of Crimes, and the SMART Office. Points of view or opinions in this program are those of the presenters and do not necessarily represent the official position or policies of the U.S. Department of Justice.
Hi, everyone. My name is Lila Silverstein, and I'm an appellate public defender from Washington State. As I understand it, you have already heard from Professors Anna Roberts and Julia Simon-Kerr regarding their groundbreaking academic research debunking the assumptions underlying Evidence Rule 609 and the use of prior convictions to impeach. Now, the question is, what do we do as practitioners with this information? One thing that we can and should do is lobby for repeal of these court rules or amendment of these court rules. But the other thing we need to be doing is litigating these issues in our cases, both at trial and on appeal. And there are several different arguments that we can be making. I'm going to talk to you about two arguments I made in a recent case and that we can continue to make. And I know you will hear from other speakers about other challenges that we can be bringing. First of all, this is the rule that we have in Washington. I know that not everyone has the same version of the rule, but I think a lot of states have rules with the same language we have in Washington. In a nutshell, any witness in any type of trial can be impeached with a prior conviction, but only if one of two conditions is satisfied. First, if the prior conviction is a felony and the probative value of the conviction outweighs its prejudicial effect. Or second, if the crime involved dishonesty or false statement, in which case it is automatically admissible. Now, as I mentioned, there are several ways we can and should be challenging the admission of prior convictions to impeach, especially when it comes to our clients, criminal defendants. But I'm going to talk about two arguments I have made as an example. First, with very limited exceptions, if any, we should argue that the use of prior convictions to impeach our clients violates their state constitutional rights, most notably the right to testify. And then second, if our clients are subject to automatic admission of a so-called crime of dishonesty under subsection 2 of the rule, we should challenge the expansion of that definition if the crime in question is something like theft or robbery, as opposed to fraud or false statement. Now, starting with state constitutional challenges, believe it or not, the Hawaii Supreme Court long ago held that the use of prior convictions to impeach criminal defendants violated the defendant's rights under the Hawaii state constitution. It's a great opinion, worth a thorough read, and it begs the question, what can we do in other states and what should we be doing in other states? First of all, why did I say we should be making these arguments under the state constitution rather than the federal constitution? We all know that our clients have an implicit right to testify under the federal constitution. But of course, we want to insulate any favorable ruling from review by the United States Supreme Court. And also, many state constitutions are more protective than the federal constitution. And that's certainly the case with many provisions of the Washington State Constitution. This is a picture of the Washington State Constitution here. And one of the key provisions of our Constitution is Article 1, Section 22, which contains a plethora of rights for accused persons in criminal trials, including an explicit right to appear and defend in person and an explicit right to testify. So, in Washington, we are arguing that the use of prior convictions to impeach violates our client's rights under Article 1, Section 22. And you can make the same arguments under your analogous state constitutional provisions. Now, unfortunately, we do have a bad old case in Washington rejecting this argument, and you may have similar cases in your jurisdictions. Nevertheless, we must keep pressing this argument. And one reason our courts should be receptive to the argument, at least in Washington, is that this bad case predated our state's radical state constitutional awakening. Our court did not really start developing an independent state constitutional jurisprudence until the early 1980s in a case called State versus Gunwale. Actually, I would say the awakening started before Gunwale in a series of cases starting in about 1980, but in Gunwale, they set out a framework for determining whether to independently interpret a particular state constitutional provision in a certain context. And they have subsequently held that several provisions of our state constitution provide greater protections than their federal counterparts in numerous contexts. And that includes the right to testify under Article 1, Section 22. In a case called State versus Martin, the Washington Supreme Court held that Article 1, Section 22 provides stronger protection than the Sixth Amendment when it comes to prosecutorial accusations of tailoring. In other words, when our clients testify, sometimes prosecutors on cross-examination and in closing argument accuse them of having tailored their testimony to what they've heard from other witnesses, even though our clients have a right to be present at their own trials, and they have a right to defend against the allegations, and they have a right to testify. Now, in a case called Portuondo v. Argard, the US Supreme Court said there's no problem with that under the US Constitution, and prosecutors can attack a defendant's credibility essentially however they want. But the Washington Supreme Court said that's not true in our state because Article 1, Section 22 provides stronger protections than the federal Constitution. Specifically, they said Article 1, Section 22 of our state constitution explicitly recognized the right of defendants to appear, to present a defense, and to testify at a time when the federal Constitution did not provide such broad protection to defendants. And so that warranted independent protections under our state constitution and greater protections under our state constitution. They said thus, at least in the context of prosecutorial suggestions of tailoring, Article 1, Section 22 is more protective than the Sixth Amendment. Specifically in Washington, prosecutors cannot stand up in closing argument and accuse a defendant of having tailored their testimony to what they heard at trial, because doing so when the defendant cannot respond infringes too much on the state constitutional right to testify. So what we need to do, and what we are doing in Washington, is arguing that the Martin analysis applies with equal force in this context, in the context of using prior convictions to impeach. In other words, our Constitution must be read independently of the federal and must be read to provide strong protections here because it explicitly guarantees the rights to testify and to defend in person. Then, once we get past that threshold issue of independent interpretation, we explain that the use of prior convictions to impeach defendants violates their rights under Article 1, Section 22 for several reasons. First of all, as we just discussed, a defendant has an explicit state constitutional right to testify, but a prior conviction is at best minimally relevant to credibility, and it creates a substantial risk of prejudice to the defendant and his constitutional rights because of the unavoidable propensity inference, which is not mitigated by instructions because jurors are human. And this prejudice is exacerbated by racial bias, where our clients are Black and brown. Our Black and brown clients are already unfairly perceived as dangerous and guilty due to implicit bias. And that problem will only be magnified by the use of a prior conviction to impeach. That prior conviction will actually be used to infer dangerousness and guilt. Now, when you make these arguments, you want to cite that good Hawaii case, Santiago, at least for the first two propositions, and you want to cite the articles by Professors Roberts and Simon Kerr, especially for the second and third arguments. Now, if you're dealing with bad existing precedent like we are in Washington, you have to address that and explain why it should be overruled. And I'll acknowledge that if you're in trial and you have a case like this, you're almost certainly not going to win the argument at trial because the court will say it has to follow what your state Supreme Court has said, but you still want to preserve the issue. And if you're on appeal, you want to zealously make these arguments. So in Washington, we're arguing that this bad 1977 case should be overruled because, first of all, as I noted earlier, it predated the era of independent state constitutional jurisprudence, but our Supreme Court has subsequently recognized that our Constitution provides greater protection in a similar context. Again, that was the Martin case, and that case should control. Secondly, Ruzicka actually reviewed a statute, not a court rule. I don't know if that's true for the bad opinions in any of your states, but this bad opinion in Washington reviewed a statute that existed before ER 609 took effect. So the court applied the doctrine of legislative deference. But a court rule is, of course, not subject to legislative deference. It's the court itself that adopts court rules. And that's another reason that this old case should either be overruled or held not to apply at all. And then third, empirical research has exposed the flaws in the reasoning the court employed back in Ruzicka to uphold the constitutionality of prior conviction impeachment. And these are things I assume Professors Simon Kerr and Roberts have already gone over with you. But just to reiterate, research shows that contrary to the Washington Supreme Court's opinion in Ruzicka and some of the old opinions in your states, prior convictions are actually poor indicators of whether a witness will speak truthfully in court. So these opinions say, sure, a defendant has these constitutional rights, but if they decide to testify, then they should be subject to the same cross-examination as everyone else, and their credibility should be challenged just like everyone else, because no one has a right to be untruthful on the stand. And, that's fine so far as it goes, but research shows that having a prior conviction really has nothing to do with credibility or very little to do with credibility in court. And the research shows something that we all know as defenders, and which is just common sense, namely that human jurors cannot help using prior convictions as propensity evidence, regardless of what an instruction might say. So an instruction might say you can only use this for credibility, but of course that's not what jurors will actually do. And then, as we just discussed, racial bias exacerbates this problem. So the bottom line is that we need to object to the use of prior convictions to impeach, both at trial and on appeal. And we need to tell our courts that bringing in these convictions violates our client's state constitutional right to testify, because these prior convictions are not relevant or minimally relevant to credibility. There's this unavoidable propensity inference that comes from the use of these prior convictions. And there's racial disproportionality in who has prior convictions and racial bias in jurors' interpretations of those convictions. And I've talked about the latter already, but note the former problem as well. Due to systemic racism, your clients of color have a disproportionate share of these prior convictions to begin with, on top of having to grapple with an increased risk that jurors will misuse the priors as propensity due to implicit bias. So because of all these problems, the use of prior convictions to impeach a defendant in a criminal trial violates the defendant's state constitutional right to testify, and therefore the evidence should be excluded. This is an important argument to be making, and one we will continue to make in Washington. Okay, so we've talked about that issue, and now I'm going to move on to a narrower challenge. Namely, if your rule, allows for crimes like robbery and theft to come in automatically as so-called crimes of dishonesty, we need to be challenging such an expansive reading of this rule. As a reminder, this is what that part of the rule says. For purposes of attacking the credibility of a witness, evidence that the witness has been convicted of a crime shall be admitted if the crime involved dishonesty or false statement. But properly read, a crime of dishonesty is a crime like fraud, not a crime like robbery or theft. Okay? Now, here in Washington, we have an interesting history on this issue. Our Supreme Court initially held, correctly, that theft and robbery were not crimes of dishonesty within the meaning of the rule, and that they could not come in under this provision. That was in a case called State versus Burton. But unfortunately, a few years later, the court overruled Burton and accepted the state's argument that this subsection should be read expansively to include theft and robbery. We need to be arguing, and we are arguing, that Burton was correct and that the cases overruling it are wrong, and we need to return to a proper, narrow construction of the rule. And we make that argument by discussing the plain language and history, just like you would with a statute. So we note that, as our Supreme Court already recognized in Burton, the case that was wrongly overruled, the language of Washington's ER 609 was taken verbatim from Federal Rule of Evidence ER 609. And under the federal rule, robbery and theft are not per se crimes of dishonesty, and instead, only crimes that directly bear on truthfulness, like fraud, fall within the rule. And that makes sense, right? Because robbery and theft don't have anything to do with lying. They involve stealing, which is altogether different. So the plain language and history show that robbery and theft are not crimes of dishonesty, and these later cases went astray in concluding otherwise and in expanding that definition. Policy arguments are also important in construing court rules, just like when construing statutes. And as a policy matter, it's important to limit admission of prior convictions to those that directly bear on truthfulness because, first of all, as we just discussed with respect to the constitutional challenge, admission of these crimes burdens the right to testify and causes defendants to either not exercise their right to testify or to avoid trial altogether and plead guilty because they don't want to testify if their priors are going to be used against them. But if they don't testify, no one will hear their side of the story and they'll be convicted. So they plead to a lesser to avoid those problems. And that's not right, given that a defendant has a constitutional right to trial. On a related note, expanding the definition of crimes of dishonesty to admit all manner of crimes increases wrongful convictions because even people who are actually innocent decline to testify. And surely the court, in adopting this rule, did not mean to increase wrongful convictions. And then finally, as we discussed when addressing the constitutional challenge, the broad admission of prior convictions only exacerbates systemic racism. Now, I recognize that the Washington Supreme Court is a leader in acknowledging systemic racism and taking responsibility to address it, and that not all state Supreme Courts share that concern or would be as receptive to these arguments. But there are a lot of state courts out there that do recognize this problem and their role in it and their obligation to address it. So don't assume that your courts won't care. And even if they don't care now, we need to take steps to make them care by educating them about these issues and moving to exclude evidence that invites implicit bias and exacerbates systemic racism. So again, the bottom line is the plain language and the history of ER 609 show that, consistent with sound policy, crimes like robbery and theft do not involve dishonesty within the meaning of the rule and cannot be used to impeach our client's testimony. Okay? So that's another argument we've been making, and those are the two issues I planned to cover today. Obviously, there are other arguments to be made, and you will hear from other people about what they've been doing, but these are the two arguments I made in a case last year. And I have a link to my brief on this slide, so you can look at the brief and see the arguments there. I will, of course, provide these slides to NACDL so you can get them if you want. And you can also email me at the address on the screen if you have follow-up questions. But the main message is, let's not roll over on our clients' prior convictions coming in to impeach. Let's object at every turn under both the Constitution and the plain language of the rule. Okay? Thank you so much for inviting me to participate in this session, and have a wonderful day.